Right, so this is criminal appeals from the Crown Court. So you've been convicted initially at the Crown Court and you're wanting to appeal on that basis. So if I just make it smaller so you can see the full page. Right, so starting at the bottom then, your case has been heard at the Crown Court, okay? And what we are working out is what your options are in terms of appeal. As you can see, it's just a straight up diagram. Okay, so it's a little bit easier to draw than the Magistrates' Appeals. And from the Crown Court, you would go directly to the Court of Appeal if you were appealing. Now, because it's a criminal case, you would go to the criminal side, whereas when we do the civil booklets, you'll see that they would then go to the civil side. Right, so I'll start with defence as always then. So this is on your right-hand side in red here. So the defence can go to the Court of Appeal, but they do need permission, right? Generally, even though our top court in the country is the Supreme Court, most cases are dealt with and finalised at the Supreme Court. At the Court of Appeal, simply because they don't end up getting permission to go higher. So you do need permission to go to the Court of Appeal because it's a very, very busy court. Why are you going then? So again, as normal, you're going against your conviction or your sentence. Okay, so you're going because you're being convicted and you don't think you should have been, or you're going because the fact that you think you should be given 6 months instead of 6 years. So they can confirm that the conviction is unsafe and can raise new evidence. So if they don't think that you should have been convicted, let's say there's new evidence that shows you're innocent, they can listen to that, but they will ask why you haven't brought that evidence up previously. So they will want to know, obviously, as a result, why you've not done that. So just be prepared for that question, because obviously, if it was plausible, you'd normally bring them in your original trial, and that's what should have happened. They can reduce your sentence, but they can't increase it. So all this is meaning is that they can decrease the amount that you go to prison for, but they can't increase it. So if you're given 5 years, you're still only going to get 5 years maximum by the Court of Appeal because they can't make it higher, but they can decrease it. So actually that bit goes in your favour. They can send it back down to the Crown Court for a retrial. So rather than making the full decision there, they can say, right, this is what you should do. Crown Court, try the case again and listen to it this way. And then finally, we've got a company, sort of a body, I suppose, really, called the Criminal Case Review Commission. They refer cases to the Court of Appeal if we feel like there's a miscarriage of justice. So what we mean by that is that justice hasn't occurred in your case. So miscarriages of justice when people have gone to prison that shouldn't have gone to prison. So like Guildford 4, Birmingham 6, Stefan Kisko. What we're looking at here is people that have gone to prison that shouldn't be. So if we think there is a miscarriage of justice, the CCRC, the Criminal Case Review Commission, will get involved and they will review that as well and send it to the Court of Appeal to look over. Okay, so in terms of conviction, they will either say it's normal or they'll say it's unsafe. With your sentence, they'll decrease it but not increase it. Right, if you want to appeal further, bear in mind that it's very unlikely because only 6 cases get to the Supreme Court. You can go up to the Supreme Court, but it's exactly the same as the other diagram. It's got to be a point of law of public importance, and you have to get permission to get there. You have to get leave. So leave to appeal is required for both Court of Appeal and the Supreme Court. Again, you can go up to European Court of Human Rights, but again, you do need leave to appeal and it must be on human rights. So you can't go to the Human Rights Court for anything else other than human rights. So that's your defence side. Now, the prosecution side, again, this top 2 here are exactly the same for both sides. So your detail has to be on here in order to get the 9 marks available, okay? Now, with the prosecution side, they're going the opposite. So they're going because you've been acquitted, you've been let off, and they don't think you should have been, or they're going because you've been given a low sentence and they think you should have been given more. All right. Now, again, they need permission. So the prosecution have got to get permission from the Court of Appeal to go up or from the Crown Court to go up. Now, in limited circumstances, what we can have is somebody called the Attorney General. Now, the Attorney General works for the prosecution and they refer cases to the Court of Appeal on particular aspects of law. Okay, now what they are doing is they are looking at the point of law. So they're looking at the particular law itself, not the facts of your case. So if you see a case and it says Attorney General reference, what's happened is the Attorney General has referred the question to the Court of Appeal. The Court of Appeal have then answered it and said this is what the law should be. So it doesn't affect the defendants. It doesn't affect your case. It affects future cases. So let's say it was involving murder. They wouldn't necessarily change your verdict, but then they might say for future cases, this is the way that we need to go about it. Okay, and that's how we get the outcome in that way. So the Attorney General refers a point of law, but he's referring a question that needs to be answered that they're not sure on. He's not actually making a difference to your decision. Also then, there used to be a law called the Double Jeopardy rule, and you'll have heard about it, seen it on TV, which meant that you couldn't be tried for the same crime twice. So if you were found not guilty, and even then you turned around and said after the trial, aha, I was guilty, we couldn't do anything about it because the trial was heard, right? That has been abolished. So since the Criminal Justice Act 2003, if we find new evidence and it suggests that you are guilty, we can have another trial and try you again for that crime, all right? But it's got to be in the public interest, which obviously generally it would be because you've been let off instead of being convicted, but that's what we do. So we can try you for the same crime twice, which is why the murder of the Leeds University student, Meredith, the defendant was guilty, they're not guilty, they're guilty, they're not guilty, they weren't sure. Because we've abolished the Double Jeopardy rule, we can actually do that and we can go and get another trial. So all that means is that even if you found not guilty, bear in mind we could end up trying you again afterwards. So, you know, look over your shoulder sort of thing. Last bullet point there then, so they can order the defendant to be resentenced. So yeah, the Court of Appeal can order for the Crown Court to go through and sentence them again in that sense and see what's going to happen. Now, if the prosecution are not happy, again, they can go up here to the Supreme Court and can go further, but they still need permission, the same as the defence. So realistically, the only bit that you need to remember that's massively different is here, because this is the same for both sides. So you just need to remember, in terms of the prosecution, why they're going, do they need permission to go, what's the Attorney General do, what is the Double Jeopardy rule, this side, why are they going, what are they going for, what can they do with the conviction, can we raise new evidence, what do the CCRC do? Okay, now this provides you with the full 18 marks that are required. So if you had to do both sides, it would get you 18 marks. If you just needed to do one side, it would give you 9. So the options are all of this sort of diagram. So all appeals from the Crown Court, all appeals from the Magistrates Court, or defence from one, both sides, and prosecution. So you might only end up drawing one diagram out, but labelling both defence prosecution, or as previously, or like you did in your assessments, how the defence can appeal from both. So this diagram with the defence on, and then you draw in the other diagram at the other side with the defence labelled as well. So it just depends. But if they want both defence and prosecution, that is how you're getting your 18 marks. 9 marks for that side, 9 marks for that side. And bear in mind, these bits here are exactly the same. So you're actually doubling your marks just for giving them the same content. Hence why this is what's worth the majority of those marks. Okay.